It is a pleasure to introduce Eric Lockwood. Eric is a legal professional with experience advising healthcare professionals, including optometry students, on immigration issues relating to studying and practicing in the US. Tonight, Eric will share practical insights into legal considerations that are especially relevant when education or career plans point to the United States. Please join us in welcoming Eric Lockwood.
Thank you so much. Good evening, everyone. Thank you very much for the opportunity to present this evening. I appreciate it very much. And before getting into the substance of the different immigration law topics that I'll present tonight, I wanted to briefly address this moment that we're currently navigating with respect to immigration law in the US. I think over the last 12 months, there's been a dizzying array of changes in immigration policy, and it can be easy for any of us to get caught up in the pace of change. It can also be tempting to get pulled into what's being generated by the rumor mill, what's posted on social media. But with all that said, I think it's really important to emphasize that there are still solid and reliable pathways that currently exist for current and future optometry students looking to stay in the US after graduation. And I'll be focusing on some of those pathways and some of those topics this evening. Along similar lines, I'll avoid speculating on any unconfirmed policy changes. So to zoom out for a moment, F1 status is one of the most stable and well-established visa categories in our immigration system. F1 status is centered on education with certain opportunities for practical training related to your field. So as an overview, F1 status requires the following. First, full-time enrollment. This means pursuing a full course of study as listed on Form I-20. The I-20 is a key immigration document that shows that you're currently in valid F1 status and is essential in being able to obtain employment authorization. Second, what's referred to as normal academic progress. This means completing the full course of study before the program end date, which is noted on Form I-20. And then third, complying with work authorization rules. As a general rule, on-campus work is limited. For example, it can't displace a U.S. citizen or a green card holder. And whether work is on campus or off campus, prior authorization is always needed. So I'd like to spend a few moments talking about curricular practical training, known as CPT, and optional practical training known as OPT, and how this can play into your U.S. immigration journey. So to start, I wanted to share a few general points about CPT. First, it's authorized by your school and not USCIS, which is the immigration agency that processes requests for immigration benefits. Second, CPT is directly tied to your curriculum. And third, it's often used for externships, clinical rotations, or required training experiences. Zooming in, some key points to know about CPT are as follows. It has to be integral to your academic program, meaning that it's required or that you earn academic credit when engaged in CPT. It can be full-time or part-time, depending on how your academic program is designed. And it's also employer-specific and location-specific, and it's tied to specific dates. So if anything changes, whether it's the employer, the location, or the number of hours you're working, in that instance, you need new CPT approval and an updated I-20. When CPT is used correctly, it can be a really great tool to supplement your coursework. One important thing to keep in mind is that using more than 12 months of full-time CPT means that you can't use OPT after graduating from your program, and I'll be speaking a little bit further about OPT in a moment. Anything less than 12 months of full-time CPT is okay, and in that scenario, you're still able to use your optional practical training after graduation. So with all this said, it's definitely feasible to use CPT or curricular practical training in a structured and valuable way so that it doesn't create issues in obtaining that optional practical training after you've formally completed your degree program. To summarize, CPT is really a commonly used tool for clinical training, and if your school authorizes it, you're using it exactly as it was intended to be used under the immigration regulations. So having discussed some of the key elements of CPT, I'd like to shift gears to spend a few moments discussing some of the key points regarding OPT or optional practical training. So OPT allows foreign students to work in the US in a job directly related to their major. You can use up to 12 months total of OPT. Most people use it after graduation. This is known as post-completion OPT. And some will use part of it before graduation, which is known as pre-completion OPT, and doing so subtracts from the 12 months of OPT that you're entitled to after graduating. This is something to keep in mind if you're considering engaging in optional practical training before you graduate. For post-completion OPT, in other words, training that takes place after you formally completed your program, timing is really important. The earliest that you can apply for an OPT work permit is 90 days before your program end date, and the latest you can apply is 60 days after your program end date. So what this means is that USCIS, the immigration agency, must receive your work permit application within that window. This application is known as Form I-765. And one critical point is that you cannot start working before the start date that's listed on the work permit, which is also known as an EAD or employment authorization document. And you also cannot start working before you physically have the card in hand. So even if you've received, for example, the work permit approval notice, you can't start working until you've received the physical work permit card itself. To apply for an OPT work permit, you don't need a specific job offer, but there are some important things to keep in mind with respect to any periods of unemployment. During post-completion OPT, you can have no more than 90 days of unemployment total. What counts as employment can vary. It can be a paid job, multiple part-time jobs, contract or freelance work, self-employment or volunteer work, but it must be related to your field of study. And then there are also important reporting requirements to keep in mind, meaning that you have to report any changes regarding your employer or any periods of unemployment to your designated school officer, also known as the DSO. One thing to remember regarding international travel. If you're traveling abroad during the OPT period, in addition to a valid passport, it's important to have with you your EAD card, an I-20 that is signed and endorsed for travel, and it is recommended to have with you proof of your ongoing employment, such as recent pay stubs. So looking at what comes after OPT, I also wanted to spend some time discussing H-1B status, H-1B being a work visa, and some of the key things to keep in mind when considering the H-1B. So as an overview, H-1B status is temporary work authorization for a specialty occupation, which is a job that normally requires at least a bachelor's degree in a specific field. And the individual being sponsored for the H-1B must have that relevant degree or equivalent experience. H-1B status is employer specific, which means that switching jobs requires the filing of a new H-1B petition. You can request a total of 3 years in any given H-1B petition, and this can be extended until you've reached a maximum of 6 years of H-1B time. There are ways to go beyond the 6 years if you have an ongoing green card process that it has advanced to a certain point. One benefit to H-1B status is that it is dual intent, which means that you can pursue a green card and lawful permanent resident status without any adverse impact to your H-1B status, which again is a temporary non-immigrant status that allows work. Many individuals who want to pursue H-1B status have to go through what's known as the H-1B lottery. This is an electronic lottery that takes place every year in early to mid-March. There is a maximum of 65,000 H-1B visas given out each fiscal year, and an additional 20,000 for individuals who have a U.S. master's degree or higher. Having a U.S. master's degree or higher does give you better odds of being selected. In terms of the mechanics, USCIS runs what's known as a beneficiary-centric lottery. What this means practically is that each foreign worker will only have one chance in the lottery, even if multiple employers submit registrations on their behalf. So USCIS will ensure that each registrant is only entered into the lottery once based on their passport information. Employers are typically notified by the end of March if a given individual has been selected. And if an individual has been selected, the employer must submit the H-1B petition itself between April 1st and June 30th for the H-1B petition to be processed by USCIS. If approved, the H-1B start date is October 1st, which is the beginning of the U.S. government's fiscal year. This year, for the first time, there will be a weighted selection process for the H-1B lottery. Under the new rules, the lottery would no longer be completely random, and instead, registrations for jobs with higher wage levels will have a better chance of being selected in the lottery than those with lower wage levels. The government groups salaries for each job and location into four wage levels from lowest to highest. Wage level 1 is usually tied to entry level positions, while wage level 4 is generally for senior level positions. And as a result, the salary offered for a position could affect the odds of being selected in the H-1B lottery. It appears that this new weighted selection process will be challenged in court, which could ultimately delay or stop its implementation. And we will continue to monitor any developments on this front. There are also some critical details regarding the transition from F1 OPT status to H-1B. If you're in your period of OPT, you're selected in the lottery, and your employer timely files an H-1B petition, so again, that's in the window of time between April 1st and June 30th, then your work authorization under OPT is automatically extended so that you can continue working while your H-1B petition is in process and even after your work permit expires. This is known as cap gap protection. This means that even if your H-1B petition is pending for several months and your work permit has expired, you still have authorization to work. If USCIS ultimately denies the H-1B petition, then the cap gap provisions no longer apply and your work authorization would end. One other important avenue that I think is important to mention is what's known as the cap exempt H-1B. This is a way to obtain H-1B status without having to go through the lottery. With that said, cap exempt employers are limited to certain categories and include U.S. universities, nonprofits affiliated with universities, nonprofit research organizations, and government research organizations. One of the great benefits of having a cap exempt employer file an H-1B petition on your behalf is that they can file at any time of the year. There is no need to wait until October 1st to change to H-1B status, unlike the H-1B that goes to the lottery that we were discussing a little bit earlier. Once the cap exempt petition is approved, you can immediately begin working at that point. It's important to note that not every nonprofit qualifies. If there's a university affiliation, it has to be formal and thoroughly documented in order for a cap exempt H-1B to be viable. So before concluding my presentation, again, I wanted to reaffirm that there are solid and stable immigration pathways, as we've discussed. Despite the many changes in the immigration world that we've seen since the beginning of last year, there are still reliable options to move forward as you progress in your studies and in your career. So thank you again for the opportunity to present this evening, and thank you for your patience and long attention, and I wish each of you the very best in your future endeavors. Thank you.
Thank you, Eric, for all that information. I know we have a few questions on the queue. One mainly is, I know it's from a student that's a specific question because she's in one of our accelerated programs at the New England College of Optometry. I know there are many other optometry schools that have accelerated programs. Can you just clarify, because the optometry degree is usually 4 years and our accelerated programs could be 2 or 3 years. All the things you say applies to them and there is no difference, correct?
Yes, that's correct.
Perfect. I just want to make sure everyone kind of knows that, irregardless of how many years in your school, that is the same. Another question someone asks is, who hires the immigration attorney when it comes to getting an H-1B?
Thank you for that question. So because the H-1B is an employer-based petition, typically it would be somebody from that employer, a point person who would reach out to the immigration attorney, engage that person and share sort of what the request is. And that would usually kick off the process. And then throughout the process, there would be some interaction as well with the employee, him or herself, the sponsored individual, since their immigration documents and academic documents are needed for the H-1B petition itself.
So all the fees will also be paid by the employer, not the graduate.
That's correct. And that's something that's mandated by the H-1B regulations themselves, is that all legal fees and government filing fees must be paid for by the employer.
And then just to clarify, when you mentioned the OPT, 90 days before you graduate to apply, and should students who are about to graduate who want to apply for an OPT, should they do it in an expedited manner or should they do that in a regular manner? And who pays for those fees?
So typically, the student would pay for those fees. I think that's the most traditional arrangement that we've seen. There are situations perhaps where they'll want to expedite processing of the OPT application, and there is a way to do that through something called premium processing. So through premium processing, which is an option the government offers for an additional filing fee, that application will be expedited to 30 business days. And that can be helpful if employment, it will be starting imminently. Perhaps the student has not yet received a decision. That can be a really helpful way to receive a decision more quickly and be able to receive that physical work permit.
Okay. Another question we have is, how do paying taxes work? Like if you're working during an OPT or CPT, is a non-US citizen required to pay taxes?
Yes, you would still be required to pay taxes in that instance. Sometimes the tax rules for foreign nationals or for those in temporary student status are different than those, for example, who are green card holders, but it still would be necessary to file a U.S. federal tax return.
Okay, here's another question. Is it true the H-1B costs $100,000 for the employer?
Yes, this is a really important question. So it really depends on whether this person is coming from abroad or whether they're in the United States and going through the process within the US. That $100,000 fee typically would apply if the person is outside the US when that H-1B petition is filed. If they're here, for example, in F1 OPT status and they're applying to change to H-1B status, that $100,000 fee would not apply.
So if you're can you repeat that last part again?
Sure. So if you're currently studying in the US in F1 status, let's say, for example, you're in your period of OPT, and there's an employer who wants to sponsor you for an H-1B, because you're physically here in the US and you're applying for a change of status, that $100,000 fee would not apply. If you were, for example, outside the US and that employer were looking to bring you to the US, then in most instances, that $100,000 fee would apply.
And that also means when you're changing status, do not leave the country because if you leave the country, things change.
That's absolutely a very, very important point. If you are applying for a change of status and you leave the country while that process is still ongoing, the government will find that you have abandoned the change of status request. They'll convert it to a different type of H-1B petition, and then that $100,000 fee would apply in that instance.
Okay, here's another question, and I'm not exactly sure what it means, but I'm going to read it directly. This person has a question regarding OPT CPT training.
Mhm.
And they're saying, as a student at the University of Waterloo, where there's an optometry school in Canada, they're wondering if completing a 4-month unpaid clerkship in the United States counts towards your 12 months. I'm not exactly sure what that means. So what happens in a Canadian school, they may do an externship,
Mhm.
rotation here in the US.
Mhm.
I'm not sure what type of visa they're obtaining. Are they obtaining an F1 visa or oh,
Yeah,
you know,
Yeah, I
yeah,
think probably we'd have to have a little bit more information in terms of the type of visa that they would be obtaining. If they're not coming in, for example, on an F1 visa, generally those timing rules about CPT and OPT would not apply. If, for example, they're coming in, for example, J1 has different options for like internships and traineeships. I'm not sure maybe if
okay,
that would be applicable.
that
In
may
that
be.
case, if, for example, that were the visa that was being used, then it would not affect any type of CPT or OPT calculation.
Yeah, that's a tougher question. I think requires someone to speak to someone like you or another attorney directly. Um, I know we have a limited time. Let me see. So what is the fee if you are on an OPT? So you went from F1 to an OPT and you're applying to an F1 again. Is that possible?
I'm sorry, the situation is a person's an F1 OPT.
F1 OPT finishes the 1 year of OPT.
Mhm.
Can they then apply to be a student again to get another F1 visa?
So for example, they're applying for another degree program.
Yes, for another degree program.
Yeah, that can be possible. Typically, the OPT, the government's just going to grant that 1 year if it's the same educational level. So, for example, if someone has 1 year of OPT after a master's degree, they go get a doctorate, they would be granted additional OPT time. If it's another master's degree, then there could be some pushback from the government for that OPT request.
I know we're done with time, but there are many other questions. And if we send it to you, Eric, would you kindly answer them for us?
Yeah, I would be happy to.
And the other thing is, do you have something written that we can provide to the students in regards to all the information you've given?
Yeah, I would be happy to provide some written materials as well.
Yes. Thank you. Appreciate your time.